Hey, so I am now going to continue with Brian Freedman's objections to Clement Theory's evidence. I hope you found part one, the first 10 we went through, quite amusing, shall we say. I find this part really fascinating. I always find it quite fascinating and a bit validating, actually, because when I was reading Clement Theory's declaration, I was like, well, that doesn't feel like a proper argument. You're just waffling now. I think I actually used the word waffle as well. It just feels nice to see Brian Friedman has had the same thought process and gone, Your Honor, he's waffling. It's not relevant. And like I say, so the judge did sustain all of Friedman's objections. We've gone through the first 10. We're going to continue from objection 11 to objection 26. Because I'm just curious to see what what else did Freedman take issue with. He's so funny. Okay, so 11, paragraph 13 in its entirety, page 3. Mr. Freedman's behavior pressed me to request Travis's client file from his firm, which I did on January 31st, 2025, and then on February 6th, 2025 by 2 FedEx letters. The reason for objection is that it's not relevant to the anti-SLAPP, and that's sustained. Objection number 12. Paragraph 14 in its entirety, page 3. On February 13th, 2025, Mr. Turnauer of Liner, Freedman, Tatelman, and Cooley responded to my request and instructed me to retrieve the case file the following day. On February 14th, 2025, I appeared at the law offices of Brian Freedman, where I was provided a flash drive containing the purported file and was asked to sign an acknowledgement of receipt of case file. Now, if we remember a timeline, because I always try to think what else was going on that day, and I'm pretty sure that's the day that Brian Freedman, I'm quite sure, would have been flustered, because didn't he get the phone call from someone who knew Taylor Swift to say that, Lively's lawyer was extorting Taylor Swift? I'm sure it was February the 14th. Which now, looking back, I think was a setup. I think Freedman definitely thought that someone was calling him in good faith with information. He wouldn't have signed an affidavit otherwise. I think it was a setup. I do. I genuinely thought Taylor Swift turned, not realizing that she was being referred to as a dragon and Blake Lively was her Khaleesi. But now I've seen the unsealed evidence and I've seen the text messages where, they're joking about the Game of Thrones reference, the Khaleesi and dragons bit, and, Taylor Swift is saying, well, I'll just say Dracarys. Now I know that actually she was aware of it the whole time. So I think this was a setup, this whole call to Brian Freedman. That's my opinion. But I think it was a planned, organised stitch up. And it worked because it got Freedman in trouble with the judge. It had two of his letters and his affidavit stricken from the record. One of them was stricken sua sponte as well. And, it did kind of make him look... It made him look bad. It gave people something to go, oh my God, he's just trying to piss off Taylor Swift and bring in, litigate this in the public and all that stuff and basically put the whole lawsuit at risk. So, yeah, my opinion now, having looked at everything, looked at all the behaviours of everyone as time's gone on, what was going on behind the scenes, the evidence we now have, and just, knowing, kind of learning what Brian Freedman is like. I do think that was Lively and Reynolds and Swift probably coordinated that setup there. Because we know Blake Lively wanted Brian Freedman to be removed from the case and at minimum to not take her deposition. and she didn't get away with either of them. But she come as close as it gets. Okay. So yeah, February 14th was the day Brian Freedman got that call from someone who claimed to know, was it Scott Swift? It was rumored to be Scott Swift. And of course, then they all made a play on the fact that Scott Swift had a major heart surgery or something. And they were like, "Oh, you're trying to, drag this poor sick man in, And here we are looking at a case involving Travis Flores and Brian Freedman. Okay. February 14th, I appeared at the law offices of Brian Freedman, where I was provided a flash drive containing the purported file, and I was asked to sign an acknowledgement of receipt of case file. I signed the acknowledgement, but added the following reservation: I did not get the opportunity to check the content of the drive. The assistant who met with me countersigned next to the added language acknowledging my reservation. Now, grounds for objection: relevance, not relevant, and secondary evidence rule. What he's saying is he's that in the declaration, Clement Uri is saying, well, this other person's member of staff at Freedman's firm countersigned my additional statement. Well, firstly, he's saying I added this additional statement, and a member of staff at Freedman's firm countersigned to acknowledge it. But neither of those things are actually in evidence. So, yeah. So that was sustained. Okay, objection 13, paragraph 15 in its entirety, page 4. The contents of the flash drive reflected very limited work performed by Mr. Freedman or his law firm. It contained no invoices, no drafts, no notes, no text, as one would expect. No evidence of any discovery conducted by Mr. Freedman or his firm. Critically, the absence of invoices prevented me from verifying whether the file was complete and whether the work purportedly performed on Travis's behalf was adequate. Okay. Relevance, the obvious one. Secondary evidence. So this is purporting to describe writings contained on a flash drive that are not before the court. Legal conclusion. The testimony is basically stating that what he believes should have existed in Travis Flores's client file to render it complete or adequate. So what Freedman is objecting to is Clement Uri basically applying his subjective opinion to what he expects should be contained in a client file. Now, we have them over here, right? The UK is like the world hub of data, like when it comes to data rights and data privacy. Like to us, data protection is as big as freedom of speech is to America. Now, we have what's called DSARs, right? Data Subject Access Requests in the UK, where you can contact an organization, your employer, a former employer, your medical records. You can request full copies of everything, and you can with law firms too, right? The police, anything that you have ever had, like dealings with, right? So this is not, you can't go to to a person, an individual, but you can to organizations. You can say, right, I was employed by you, or I bank with you. I want all my records, everything. And that has to include, I mean, you are better off specifying and giving dates and times and where you can, but you can be pretty broad over here, and you can say, look, I want all records you have on me, and that includes, and it would be hand notes, drafts, letters, complaints, any disciplinaries, CCTV footage, any voice notes, text messages. And in the UK, we have to keep everything. And if someone requests it under a formal DSAR request, then all of that has to be collated. Now it is reviewed, and if it, like, under things like safeguarding, children's safeguarding, for instance, you might not get access to that because there is a purpose there. There's a justifiable reason for you not to have it. Stuff might be redacted to protect someone else's data or identity. But basically, data that pertains to you, if you are the data holder or you are the representative of the data holder, i.e., you are the parent of a child and you want their medical records, as a parent, you have the legal right to obtain their medical records, until they hit a particular age, where they can request it themselves. And I know that it's, what we would do is, if it wasn't complete, we would not file a lawsuit. This is the bizarre bit of this, I do find. I'm not saying it's the only claim, but like, why are we filing a lawsuit? Did he go back to Freedman's firm and say, hold on a minute, where's the rest? I have not seen him mention that, actually. Because that's what we would do in the UK. If you had all the information, you're like, well, hold on a minute. I'm this refers to an email which is not included in this. Where's that email? Or if there's stuff missing, there's big gaps, or even redactions that you're like, I don't understand. Why have you redacted that? Can you explain? The reason they give is not good enough. There are channels you are expected to address it with the organization first and give them reasonable chance to put it right. And if that does not work, you can take up a complaint with the Information Commissioner, the ICO. Now, I know it's probably not identical, but I mean, the first line of going back to, in this case, did Clement Ziori go back to Freedman's firm and say, hold on a minute, there's stuff here I would, like, where's the rest? Where's he? He knows what is missing. He's, in his, he's saying there was this long list here. He's saying, well, it didn't contain any drafts, notes, text, as anyone would expect, no evidence of discovery, no invoices. So why has he not gone back to Freedman's firm and said, hold on a minute, there's all this stuff missing, where is it? And that bothers me quite a lot. It does bother me quite a lot. It just feels like he's, although there were other grounds, I'm not saying there's, he's here with other causes of action, but why did he not go back and get the rest of the information? Because it could have been a genuine oversight, as opposed to screaming malpractice or breach of fiduciary duty, etc. Okay. Lacks foundation and personal knowledge. So declarant fails to lay any foundation or basis of personal knowledge for his testimony about what one might expect to find in a client file. I think that's fair. Improper opinion testimony. Declarant's testimony about what one would expect to find in the client file is improper expert opinion and unqualified lay opinion. Again, I agree with that. So now they've asked the court to strike portions of Melissa Yeager's statement too. Now, obviously, Claire Wineland's mother, Brian Freedman, clearly said, look, this is just hearsay. It's hearsay, and there's she's made legal conclusions that she's not qualified to make. And that's something I actually agreed with him. 100% agreed with him. So objection 14, paragraph 5, page 1, lines 22 to 24. Because of Claire's public advocacy, her name has sometimes been referenced by third parties in connection with entertainment projects relating to cystic fibrosis. Now, again, the fact that Claire Wineland's name has been used by third parties, and she's not saying Baldoni or Wayfarer here, she is saying her name has sometimes been referenced by third parties, right? So at this point, she's actually talking about different people, different organizations. You're not actually talking about Baldoni or Wayfarer. And again, the first argument here from Freedman is relevance. Well, yeah, exactly. Why is this relevant? This has nothing to do with the anti-SLAPP motion. You're just throwing this in there. You're saying, well, my daughter is often taken advantage of by, unscrupulous people who use her name in connection with entertainment projects relating to cystic fibrosis. I agree. It's anti-slap. Not anti-slap, sorry. It's irrelevant. And then you got hearsay. It's purporting to recount or summarize out-of-court statements by third parties. It constitutes hearsay that does not fall within any exception. Judge agreed. 15. Paragraph 7 in its entirety, page 2. But Claire did not write 5 feet apart, nor did she co-write it. However, she was consulted on the script and participated to a reading with the cast. Again, relevance, because we are not relitigating the original Travis Flores case here. So this is irrelevant. They can't go back and have a do-over of that case. That settlement agreement made that very clear. It absolved everyone, including Travis Flores, of any wrongdoing, liability. You cannot bring claims, for now or forever going forward, even if you suspected or unsuspected or knew or did not know. And the wording was so tight that there is nothing that I can think of off the top of my head where they could bring the original case back to be relitigated. And Travis Flores is not here. So, but this commentary, this line that in this objection, Claire did not write 5 feet apart, nor did she co-write it, but she was consulted on the script and participated to a reading with the cast. That's information that would have gone into the original litigation. Travis Flores' original lawsuit. It has no place in this. They are talking about different set of circumstances and technically a different set of parties, because Brian Freedman was not a defendant in the original litigation and Justin Baldoni is not a defendant in this litigation. So it's irrelevant really what Claire Wineland did in regards to 5 feet apart. And I mean that kind of respectfully, but that if we're being black and white about this, like in terms of what is relevant to respond to this, to a motion to strike and an anti-slap, this is not it. Lacks foundation and personal knowledge. Declarant fails to lay any foundation or basis of personal knowledge for her testimony about Claire Wineland's participation in or role in connection with 5 feet apart. And again, true, there's no foundation there. She just says, well, this is what she did. She needs to say how she knew. I was with her during her role consulting on this film. I personally observed what she did and what she did not do, and then say this is what she did and this is what she didn't do. You can't just say like as status fact, oh, she didn't do this, because Claire is not here and her mum may not be aware unless she was there and personally witnessed it. She may not be aware of everything that she did or did not do, and the role may have changed. And we've seen how roles on a film can change, just through the Lively case. You start as an actress, you end up taking over the damn thing. It's obviously that's not what happened with Claire Wineland, but the role may have changed slightly. She may have brought something in at some point where they decided to give her more or less of a participation in this. We don't know. But that's the point. Neither does her mum. Can't be 100% sure unless she was there herself. And if she was there herself, what Freedman is saying is you haven't. That hasn't been stated. It has not been. The foundation has not been laid. Judge agreed. Okay, 16. Paragraph 8 in its entirety, page 2. I have communicated that information on multiple occasions to Travis Flores, who related to me sharing that information with his attorney while pursuing his copyright infringement lawsuit against Justin Baldoni. Again, no relevance whatsoever. And hearsay. She's talking about statements about Travis Flores, who, again, is deceased, not here to confirm or verify anything. she was never contacted by Brian Freedman, but according to her, Travis Flores told her that he shared the information with Brian Freedman. He may well have, but that, that's not enough. She needs to be it's hearsay, basically. Yes, okay, sorry, I lost my place then, right, so 17. Paragraph 9 is entirety, page 2. I was never contacted by Travis's attorney, Brian Freedman, in relation to Travis's copyright dispute with Justin Baldoni, or I would have been transparent with him regarding the above. Travis wrote the storyline. Now, I had a big problem with that sentence. Travis wrote the storyline. I have a huge problem with that. Because Justin Baldoni did not write the story, right? This is a confusing thing, right? He was sued, Wayfarer was sued, but were just adapting a book. Same as It Ends With Us. It would be like saying, well, someone else coming up with an almost identical scenario to Colleen Hoover for domestic violence, which I don't think anyone would, because Colleen Hoover's version of what domestic violence looks like is not the reality of most women. But imagine that we were this was It Ends With Us, right? And someone sued Justin Baldoni and Wayfarer for adapting Colleen Hoover's book, but did not sue Colleen Hoover for copyright infringement. The book was written already, and Justin Baldoni adapted it into a script and made a movie. So, but the authors of the book were not sued. And that does not, and probably never will, make sense to me. Why? If you think your work has been plagiarized, why are you not suing the people who potentially plagiarized it? Why are you suing the guy who's just turning it into a film? But she cannot know who wrote the storyline for 5 Feet Apart. She cannot know that. She cannot definitively know Travis Flores wrote it because, and I said before, people can and do have the almost identical ideas at the same time. Happens a lot. It then becomes a race to, who copyrights it, who patents. So obviously the grounds for objection relevance, and it's not relevant. Lacks foundation and personal knowledge. Declarant fails to lay any foundation or basis of personal knowledge for her testimony that Travis wrote the storyline. Judge agreed. Objection 18. Paragraph 10 in its entirety, page 2. This is most of the declarations, by the way, which we've done a separate video reading the declarations. These objections apply to the vast majority of both of those declarations. Okay, paragraph 10 in its entirety, page 2. I knew Justin Baldoni personally during Claire's lifetime. I interacted and communicated with him on multiple occasions in connection with public-facing projects, events, and/or activities involving the cystic fibrosis community. The statements in this declaration regarding Mr. Baldoni are based on my personal observations and my direct communications with him, as well as my communications Claire shared with me as she was passing. It's not relevant because, again, we're not relitigating the original copyright lawsuit. But also, it is hearsay, because what she's saying there is she's trying to provide testimony to recount or summarize out-of-court statements which were made to or by her and Justin Baldoni and Claire Wineland and or any other person, because she also references the cystic fibrosis community. It constitutes hearsay that does not fall within any exceptions. Like, she can't speak for Justin Baldoni. She can't speak for Claire Wineland, and she cannot speak for the cystic fibrosis community. Paragraph 11 in its entirety, page 2. Sadly, Claire passed away prior to the release of the film. Prior to her passing, she took issue with the way Baldoni seemed to use many sick people for his own career advancement without any compensation. Before I go any further, I mean, I have a problem with that already. Obviously, Claire Wineland has sadly passed away, and her mum is saying, well, prior to her passing, she took issue. How? What did she say? It really doesn't matter what she said, though, because she's not here, so it would be hearsay. But, like, seemed to use, so that's an opinion. There's no proof there. Seemed to use many sick people. Who are these sick people? What kind of, what evidence? Who are the sick people? When and where did he use them? How do you know he used them? Of course, we can't ask Claire Wineland this. And this is problematic. I mean, it's irrelevant, again, but I'm just to kind of dissect the statement to show this is why this. I feel very sorry for Melissa Yeager, and I'm sure she's it's very sad she's lost her daughter, and I'm sure she is has thoughts and feelings. We don't know what they are based on or how accurate they are, but she's entitled to her opinions and her beliefs. However, what pisses me off about them being put into a declaration, into a legal filing, is they are so broad, they're kind of unprovable, but you watch Lively and all her minions and her sycophants jump on this and go, oh, see, look. But this is not proof of anything at all. And I don't like to have to kind of pull apart, statements, chunks of statements like this. But things need to be backed up. If you're going to say something about someone's character, it needs to be backed up. And this is just thrown into a legal declaration. And I can see why Brian Freedman has taken an issue with it. And I can see why the judge has actually gone, do you know what? I agree. And sustained the objections. Primarily, the show My Last Days is one example, as she was featured in an episode and not compensated for it. Again, how do we know? She was in one episode, right? I've got a family member who has multiple sclerosis. I think I said this in part 1, actually, but she was featured on a documentary talking about her experience with living with multiple sclerosis. And, she was not compensated. She didn't expect to be. She was just happy to be there to raise awareness of, her illness and what life can be like for people who live with the illness. Problems with the system, how the system's let them down. So it's not just the physical being unwell. It's like access to welfare, access to, hospital waiting times, getting her home adapted, so on and so forth, those kind of things, where society kind of fails broadly, holistically, not just, I don't feel well today and this is what it feels like and these are all the medication I got to take. It goes beyond that. And you get a real snapshot into what life is like with these kind of limiting conditions. And it's warts and all, so it's the good, the bad, and the ugly, so to speak. And yeah, she didn't expect to be compensated for that at all. She and I don't know what the agreement was. I don't know whether Claire Wineland was compensated or not, and why she was not. And did she know that up front? Because I can't imagine that she wouldn't have known that up front. If she was expecting to be paid, surely that would have been something that would have been put to her up front, and she could have declined to appear. I have an issue with that, but to sort of say, well, yeah, no, Justin Baldoni was a shithead and used people because Claire Wineland was in an episode of My Last Days and she wasn't paid for it. It raises a lot of questions for me, like what were the terms of the agreement? Did she know this going into it? Did she have a choice? Of course she had a choice, but that's the crux of all of this. Because if she was aware that she wasn't going to be compensated and still went into it, well, then she's made her choice. If she was told she was going to be compensated and then wasn't, well, that's an entirely different argument. Then we're looking at promissory estoppel. Okay, so relevance. Not relevant, of course. Lacks foundation and personal knowledge. Declarant fails to lay any foundation or basis of personal knowledge for her testimony that Justin Baldoni seemed to use many sick people for his own career advancement without any compensation. And hearsay. To the extent the testimony purports to recount or summarize out-of-court statements made by or to the declarant or Claire Wineland or any other person, it constitutes hearsay. Judge upheld all of that. Sustained. Objection 20. Paragraph 12 in its entirety. So now we've lost what has been sustained objection-wise in its entirety is 3 consecutive paragraphs, 10, 11, and 12. There's a lot, but this is now the third paragraph successively in a row. Claire cared about authenticity and making sure sick people were not exploited. Baldoni mentioned to Claire that she would be linked to 5 Feet Apart as the inspiration behind writing a movie about a boy and girl that could not be together due to both having cystic fibrosis. During a conversation they had about how people with cystic fibrosis could not date. That was the extent of the inspiration. Well, that was the movie, to be fair. Boy and a girl cannot date because there are distance rules in place for people with cystic fibrosis. She concedes that Justin Baldoni and Claire Wineland had the conversation about that before the movie was, put into production. So this was not a shock. And again, did Claire Wineland object to this? Well, I failed to see that she did, really, because she was taken on as a consultant, and she, I've seen lots of photos of her with both Justin and Emily, where she, seemed quite happy. I think this was as they were going through the production of the movie. They're on social media. So how much objection and pushback was there? It doesn't sound like there was much. But also, I don't think the movie went much further than the fact that the boy-girl could not date because of distance. And this is where I take a bit of issue with Travis Flores saying, well, this was all my idea. Now, he may well have had the idea, but it's quite plausible that someone else living with cystic fibrosis could have had a very similar idea, about a boy and a girl who fall in love, but they can't come together because of distance rules. It's a love story that in a very niche world that most of us won't live in. There isn't. I didn't see much more to it than that. That was like the basically the plot, the overarching plot was these two people fell in love and couldn't be together. And it really wasn't much more complicated than that. So it's just my opinion, but people can have, when the ideas are that non-specific, they can have the ideas around the same time, especially as the ideas seem to be coming out around the time that the distance rules had come into force. Okay. We did not hear anything further until he asked her to consult on the script as a person living with cystic fibrosis. Okay, so Freedman says, not relevant. True. Lacks foundation and personal knowledge. Declarant fails to lay any foundation or basis of personal knowledge for her testimony concerning anything that Justin Baldoni allegedly did or did not do. Again, that's true. Hearsay. To the extent the testimony purports to recount or summarize out-of-court statements made to the declarant, Justin Baldoni, or Claire Wineland, or any other person, it constitutes hearsay. Judge agrees. Objection 21, paragraph 13 in its entirety, page 3. So this is now the fourth consecutive paragraph. In my interactions with Mr. Baldoni, he made statements and representations to Claire, to me, and or to Claire's Place Foundation about supporting or benefiting Claire and or the cystic fibrosis community in connection with the film and its public attention. These representations included assurances that there would be tangible benefits to the community and or the foundation tied to the use of Claire's name and image and the film's association with cystic fibrosis. In other words, aside from her compensation as a consultant and the loan Justin Baldoni and his companies made in excess of $94 million, neither Claire nor her foundation nor anyone associated with Claire benefited, and Mr. Baldoni did not keep his promises. I mean, I'm not quite. They're not specific on what the benefits are supposed to be, and she was compensated for this role, but she's like, well, yeah, but he made $94 million. What is she saying here? He could have given more. I'm. Sounds like someone's a bit unhappy that either they or their daughter or their foundation did not get more money because Justin because Justin Baldoni and Wayfarer Entertainment made a lot more money. Now again, that is not something you is going to happen at the start. You when you set out to make a film, you don't know how much it's going to make when it premieres. We know It Ends With Us had a really small budget. Yeah, it did huge. It was a huge success. But that wasn't known or expected at the time. And it's not as simple as, well, they just make the money. Other people have to be paid, all the cast and crew. There may be financiers or, partnership, like production companies who are partnered who are entitled to certain cuts as well. It's not as simple as, well, he made in excess of 94 million, so he could have given us more. I'm not saying he couldn't have, but I'm not quite sure what she's expecting, and she's not being specific here. At the end of the day, she got compensated 5 minutes ago. The complaint was that she was, asked to do an episode of, My Last Days, sorry, and she wasn't compensated at all. Here, she has been compensated for her role as a consultant, but her mum is saying, well, apart from that, though, we didn't get anything. Well, what are you expecting? It raised awareness of both Claire Wineland. It absolutely put her name out there. I associated her being the inspiration for the film. It made me aware of her, and then I could, research and find, her Claire's Place Foundation. So it did raise awareness. Again, when she says the foundation did not benefit, I had a problem with that because there was a lot more awareness of both Claire and her foundation as a result of it. Definitely. Right. More importantly, it's taken away the opportunity for us to make a movie or content about her, as has already been used by Justin Baldoni, though the story is not based on her life experiences. Exactly. So she caveats there, well, it's not based on her life experiences. So what's she on? I don't understand what she's talking about. It's taking the opportunity away for us to make a movie or content about her. If the film is not based on Claire Wineland's life experiences, and again, Justin Baldoni made it clear she was the inspiration for it, but he never claimed that it was about her life, then there is actually nothing stopping Claire Wineland's mother or anyone really making a dedicated movie or content about her and her life experiences. Relevance? Yeah, it's not relevant. Hearsay? It's definitely hearsay. Lacks foundation and personal knowledge. Declarant fails to lay any foundation or basis of personal knowledge for her testimony concerning anything that Justin Baldoni allegedly did or did not say or do, how much money Justin Baldoni and his companies made, Her allegation that Baldoni did not keep his promises or the opportunities that might have existed to make any movies or content about Claire Wineland. Yeah, maybe I should stop talking and I can just read, because Freedman kind of sums up how I feel. Objection 22, paragraph 14 in its entirety, page 3. Based on my observations and to the best of my knowledge, many of those representations were not ultimately fulfilled. Again, objections on the ground of relevance and hearsay. Lacks foundation in personal knowledge. Declarant fails to lay any foundation or basis of personal knowledge for her testimony that certain unspecified, because there was no specification that representation of what these representations are, that certain unspecified representations were not ultimately fulfilled, or any other suggestion about what Justin Baldoni allegedly did or did not do or say. Judge agreed. That is my problem with this, with both of these statements. Is it's like, oh well, he said he was going to do this and he said he was going to do that, but then they don't specify what it was that what's he going to do, when's he going to do it by, how's he going to do it, how do you know he didn't do it? Objection 23, paragraph 15 in its entirety, page 3. I endeavoured to address these issues in a measured and non-adversarial manner. I'm just going to interject right there. She does not say, she says I endeavoured to address these issues in a measured and non-adversarial manner. How? Did she ever go back to Justin Baldoni and say, hey, you said you were going to do all these things, but you haven't done them? Did, much like, did Clement Ciori go back to Brian Freedman's law firm and say, hey, all this stuff is missing. I wanted the entire file, but I've noticed that there's all these things missing. Where are they? Why are they not included? People don't seem to be going back and giving people a fair chance before putting them on a public blast to say, oh my God, what a shithead. It could have been that actually he promised to do some stuff and didn't, but there may be actually really, really good reasons. We just don't know that. And she does not know that because she didn't go back and ask him. And stuff like that bothers me. Like, at least give people a fair chance, It may look it may look terrible on the surface and you might be pissed off, but there might be an explanation behind it if you bother to ask someone. But the reason people normally don't ask someone is because they don't want to know the truth, because it doesn't fit their narrative. They're quite happy just, telling anyone who will listen, hey, this person, my experience of them is this. They don't want the context. Okay. I deliberately refrained from escalating the dispute publicly or engaging in public confrontation. Again, she didn't have to. She could have contacted Baldoni privately. She has, by her own admission, she has had contact with him and knows him personally. In part because I hoped and expected that Mr. Baldoni would honour the commitments and assurances he had communicated to Claire, to me, and or to Claire's Place Foundation, and that positive community benefits would materialise. Again, with what commitments and assurances? What was he going to? What were you expecting him to honour? Relevant? It's not relevant. Hearsay? Yes. Self-explanatory at this point. Declarant fails to lay any foundation or basis of personal knowledge for her testimony regarding anything that Justin Baldoni allegedly did or did not do or say. The unspecified commitments and assurances that Baldoni allegedly communicate to Claire, to the declarant, that would be Melissa Yeager, and or to Claire's Place Foundation, or the basis for her belief that community benefits would materialise. Judge agrees. Objection 24. Paragraph 16 in its entirety, pages 3 to 4. As part of that approach, I exercised restraint and forbearance, choosing to handle concerns privately and respectfully, despite my discomfort with certain public statements made by Justin Baldoni and his companies. What statements? And unauthorized promotional uses of Claire's image to support Justin Baldoni's movie. I did so to avoid unnecessary conflict and to protect Claire's emotional well-being. Right, so that suggests that Claire was actually alive at the time. If you're trying to protect her emotional well-being, like how then where's the evidence that the images were unauthorized? Because she did work with Justin Baldoni during the production of this movie. I'm not saying what she's saying isn't true. I'm just saying you need to back it up. You can't just say these things, and put it in a declaration and say, no, believe me, trust me, bro. We need the evidence for this. Who didn't authorize the promotional use? Did Claire send an email to Justin and say, hey, don't use my images? I did so to avoid unnecessary conflict, to protect Claire's emotional well-being, and because I believed it was in the best interest of the cystic fibrosis community and the foundation to pursue constructive outcomes rather than public controversy. My focus remained on protecting Claire's dignity and the integrity of the cystic fibrosis community, while still hoping that promised support would be provided. Objections on the ground of relevance. Hearsay, to the extent that testimony purports to recount or summarize out-of-court public statements made by Justin Baldoni and his companies and unauthorized promotional uses of Claire's image. It constitutes hearsay. Lacks foundation and personal knowledge. Declarant fails to lay any foundation or basis of personal knowledge for her testimony regarding anything that Justin Baldoni allegedly did or did not do or say, any promotional uses of Claire Wineland's image to support Justin Baldoni's movie, the presence or absence of any conflict, or what was in the best interest of the cystic fibrosis community and the foundation. Judge agrees. Right, near the end now. Last but one. Objection 25. Paragraph 17 in its entirety, page 4. Based on my experiences and observations and based on what Claire communicated to me, I formed the perception, so this is a perception, that Mr. Baldoni benefited publicly from association with sick or vulnerable individuals, including by using those associations to promote himself and or projects. I had a huge issue with this. And I would have been surprised if Freedman didn't. So the obvious grounds, relevance. It's just not relevant to this action at all. Hearsay. It is hearsay because part of what she says is, based on what Claire communicated to me. And, she didn't actually have knowledge that Justin Baldoni benefited publicly from association with sick or vulnerable individuals. And that's a serious allegation to make. That's a really strong accusation. And there's no reason for that to be in this, in her declaration. There's absolutely no reason for it in this action at all. So this one, it did really piss me off actually, because there's literally no evidence, and she even admits effectively it's nothing more than her opinion, and she doesn't say where she's got that opinion from. Lacks foundation and personal knowledge. Obviously, declarant fails to lay any foundation or basis of personal knowledge for her testimony concerning the perceptions she formed of Justin Baldoni, or any suggestion about what Justin Baldoni allegedly did or did not do or say. Judge agreed. Last one. 26, paragraph 18 in its entirety, page 4. So this is almost her entire declaration, by the way. The judge has upheld all of Freedman's objections. Has sustained. Okay. I make this declaration to provide accurate information. It's an opinion. It's not accurate information. It's an opinion. Regarding A, Claire Wineland's lack of involvement in the development or writing of 5 Feet Apart, and B, my observations concerning Justin Baldoni's character on promises and assurances made to Claire, to me, and or to Claire's Place Foundation in connection with the film's use of Claire's image and its public messaging. Grounds for objection. not relevant. Hearsay. Lacks personal knowledge. Declarant fails to lay any foundation or basis of personal knowledge for her testimony concerning Claire Weiland's lack of involvement in the development or writing of 5 Feet Apart. Declarant's observations concerning Justin Baldoni's character on promises and assurances, or anything declarant says or suggests that Justin Baldoni allegedly did or did not do or say. So there we go. We're at the end of that. I like that. I was going to get to that before the judgment, but then the judgment came down, so I thought, well, I better get to the judgment. Yeah, and obviously the judgment itself, because I was going to go through the objections before we had the outcome, the judge's ruling on them. But obviously the actual opinions then were part of the order, basically, agreeing in part with Brian Freedman's special motion to strike. So yeah, I find it interesting to go through some of this stuff and just like when you forensically look into what goes into a declaration, like how meaningful is it? What are the words? Is there anything to back it up? And when you start pulling it apart, it really, like in this case, in this lawsuit, both of these declarations to me were just a load of hot air. And I do express the same skepticism over the timing of all of these things coming together. I don't love it, put it that way. But I don't know what it means. I'm not going to leap on the, oh yeah, no, these people are being paid by Ryan Reynolds. This smacks of Ryan Reynolds. It's just very coincidental, is it not, that there's so many people like, suddenly coming out and saying, yeah, we've all now got a problem with Justin Baldoni after saying nothing. Like this woman apparently had issues with Justin Baldoni but said nothing. I just find that weird. But I mean, to say that someone is using sick and vulnerable people to benefit them, it's a bit like hearing Ryan Reynolds in his Deadpool outfit, in the I think it was in the outtakes when where he's like, and I monetize the women's movement. It's that kind of thing, like that kind of suggestion, like, yo, this guy he's just taking advantage of all of these vulnerable people. And if people keep doing this, right, if this turns out to be not true or there's no evidence of it and it literally is just her speculation and she's put it in a publicly filed declaration, whilst Justin Baldoni is going through this high-profile litigation trying to defend his reputation against Blake Lively, then at some point, people are going to stop wanting to represent and try and raise awareness of these big issues because they're just going to be accused of taking advantage of people. And I find that such a, like that worries me, to live in a world like that where people are too scared to say or do anything to try and help. Anyway, so yeah, I hope you enjoyed that. So 3 of the causes of action, the breach of contract, the breach of fiduciary duty, and legal malpractice claims in this case are moving forward. The defamation and invasion of privacy are out. So they're not moving forward, and I will keep you updated as we get more stuff coming in. I don't think there's anything scheduled for a while, so it might be May, I think, the next hearing. Yeah, I'm pretty sure the next hearing is scheduled for May. So, which is going to be, busy time because the main trial is also scheduled for May. All right, guys. I'm going to do something. I think I'm going to look at something in Colleen Hoover's deposition transcript I want to go back over. So I'm going to do that in my next video.